So, a trustee is a very important person because when it's time for that trust to be administered after death, the trustee is going to be the person responsible for ensuring that the terms of the trust are carried out and executed properly. Therefore, it's very important when selecting a trustee that you choose somebody who's responsible and is capable of carrying out your intentions that are set forth in the trust agreement. A trustee is a fiduciary, so a trustee owes fiduciary duties to the beneficiaries of the trust. A fiduciary standard is a very high legal standard, so the trustee must be very careful when dealing with trust assets. If the trustee does something irresponsible, then the beneficiaries have a legal claim against the trustee for breaching fiduciary duties that were owed to them. Standard trust administration, there's a number of things that a trustee needs to do. The first thing is under Arizona law, the trustee needs to notify the beneficiaries that they're now trustee and they need to provide the beneficiaries with a copy of the trust agreement that affects each beneficiary's interests. If the trustee doesn't do this, then the beneficiaries have a right to that information and could potentially take the trustee to court to get it. So the first issue is the trustee notifying beneficiaries of the trust of the appointment of the new trustee. Then the second thing that a trustee needs to do is safeguard trust assets. It's important that the trustee take possession of those assets so that there's no waste committed. Because if there is, again, the trustee opens themselves up to liability from the beneficiaries. The trustee also needs to notify potential creditors of the estate of the deceased that a trust administration has been open and give those creditors time to present potential claims against the trust estate. So in Arizona, they can publish a notification in the county where the deceased was domiciled at the time of the deceased death. And then that triggers a 4-month waiting period for any potential creditor to file a claim against that trust estate. And then ultimately, after all the expenses have been paid, the creditor notification period expires, the trustee needs to distribute the assets to each beneficiary as provided for in the trust agreement. Now, it could be that there's ongoing obligations of the trustee. For example, if the trust had a minor child, then that trustee may have to continue to administer that trust until the child reaches a certain age. If that's the case, they can use the trust money to pay living expenses, educational expenses for the child, so long as the trustee deems that distribution to be appropriate under the terms of the trust agreement. So there could be a number of issues that arise during the course of the trust administration, as I just stated. And it's important, again, to really give careful consideration into who you select as trustee because that person is going to have a very central role in carrying out your estate plan. The most prudent consideration in managing trust assets is selecting a responsible trustee. The trustee has a duty to make sure that those assets are managed effectively and efficiently and that there is no waste being committed. So, for example, if you selected somebody who wasn't capable of being a trustee and now they're in charge of hundreds of thousands or millions of dollars and their friend comes along who says, I have a great crypto investment, will you give me $1 million from the trust? I'd really appreciate it. And the trustee does that, and then the next day the investment goes completely south. Well, now that trustee is going to get sued by the beneficiaries for wasting that money. It doesn't matter if the trustee thought that that was a good investment because no other reasonable person would assume that. So it's very important in choosing who your trustee is to manage the inheritance of the beneficiaries. Now, sometimes people will say, I don't know that I have a particular person who's responsible or capable of doing this. I don't know what to do. In that situation, you have a couple of different alternatives. You have a bank or a trust company. Now, these are professional trustees who have experience managing money. They're bonded. So if something does go wrong, the beneficiaries have a pocketbook to collect from. So those are your traditional banks and trust companies. They have wonderful experience in not only managing assets, but they are also good at managing the personal relationships with the beneficiaries. And then below them, you have something called a private fiduciary. So a private fiduciary is licensed with the Arizona Supreme Court, and they're typically small business owners who are in the business of managing estates. And typically they deal with smaller estates than a bank or a trust company, but these people also can be an alternative when you don't know if you have another suitable person to carry out the wishes of your trust agreement. Under Arizona law, the first thing that the trustee needs to do once they're appointed is provide notification to the beneficiaries of the trustee accepting those duties. With that notification, the trustee also needs to give each beneficiary a copy of the trust that sets forth what the beneficiary's interest is in that trust agreement. So by doing that, that trustee is providing notification to the beneficiaries of what they can expect throughout the term of the trust administration. Now, if the trustee doesn't communicate effectively with each beneficiary and share information that the beneficiary is entitled to, that can cause potential issues between the trustee and the beneficiary. And this can also become problematic when the trustee is also a beneficiary. A lot of times, mom and dad will designate one child to serve as trustee and manage the inheritance for each of their siblings. And if the other siblings either feel slighted or get jealous because, one was appointed and they weren't, then that's going to cause issues and frictions in that relationship. So it's very important that the trustee communicate to each beneficiary in order to avoid those conflicts, and especially in the context where the trustee is also a beneficiary, because if there is some potential issue, it could get dragged out into a nasty legal fight, which could be avoided simply through better communication. Once a trustee assumes the office of trustee, there's a number of legal notifications and duties that the trustee needs to carry out. The first and most important component is to provide notification to the beneficiaries of the trustee's appointment and copies of the trust agreement which affect the beneficiary's interests. The second thing is the trustee also needs to provide notification to known creditors and unknown creditors so that there's no outstanding liability that could exist and potentially cause the trustee to incur personal liability if they distribute assets prematurely. So it's important that the trustee carry out those two responsibilities once appointed so that they don't run into any issues down the line. If you have any questions about being appointed trustee of a trust or any trust administration issues, give us a call and we're happy to have a consultation with you at no charge.